Hello guys and welcome back to my new video. So today I would be discussing section 16 of the Specific Relief Act in detail, and I hope that you will like this video and do watch my other videos also. My content is quite informative, I believe, and I will soon be bringing much more good videos. So let's begin. Firstly, I would be discussing in a few sentences as to what is cause of action, because that is a very relevant thing to be discussed here beforehand. So, cause of action is nothing but the existence of a legal right and the particular legal rights violation. So, what this particular thing gives the right to a person to file a suit. So, suppose I am a person A, I was into a contract with a person B. B violated my rights. So, I had rights under the contract, but till those particular set of rights weren't violated, I could not file a suit. So but when my rights were violated, the particular contract was breached, so I ended up filing a suit. So that is what is a cause of action. So cause of action for a layman to understand is nothing but a particular incident, a particular set of circumstances or bundle of rights, as we say in law, which enables a particular person to file a suit. So let's begin. Section 16. Specific performance of a contract cannot be enforced in favor of a person who has obtained substituted performance of a contract under section 20. Now, this particular exception is also discussed in section 14A. It's almost the same thing, rather it is the same thing that was in nature of a contract. This section was talking about the kind of contracts which could not be specifically enforced, and section 16 is more in the nature of a person being barred from seeking this particular relief. So it's just one and the same thing. So kindly refer to my previous video for this particular exception. So clause B: who has become incapable of performing or violates any essential term of the contract that on his part remains to be performed, or acts in fraud of the contract, or willfully acts as variance with or in subversion to the relation intended to be established by the party. So I would be taking up an example here. There is this particular person A and B. A entered into a contract with B. A for the buying of 100 kgs of wheat. So this person B was supposed to sell this 100 kg of wheat to A. But what happened was that this particular 100 kgs of wheat was stored in a godown. It rained heavily one particular night, and this entire lot of wheat got destroyed, and now it was not possible for B to fulfill the contract. However, A had certain rights as a part of that contract which they entered into. So what A did, he filed a suit against B for breach of contract, seeking number A, specific performance of the same, and number 2, damages. So now let's talk in context of this particular exception. Now this person A, though this person B, now he can't perform the contract. He in the suit says that I can't perform the contract because I don't have those 100 kgs of wheat now, and the season is also gone, and it is a crop thing and I can't grow it, and all those practical arguments he gives in the court. So I can't perform it. But then he in his WS, that is the written statement, ends up saying that I can't fulfill my contract, but A has to give me the price for this 100 kg of wheat. Now just think for a second that it is extremely illogical. I am someone, I cannot perform my part of the contract, even if it's a practical reason, my own whims and fancies, or in this particular example, a force majeure kind of a situation. But I want that the other person has to perform his part of the obligation. Now, why should A pay to B for the wheat which he has not at all received only? So, this is what is section 16B tending to say. Who has become incapable of performing or violates any essential term of the contract that on his part remains to be performed. Now B has violated his part for whatever reason, let's ignore that. For whatever reason, B has violated, he has not been able to fulfill that essential term of the contract. But yes, he wants that the favors, the rights which existed for him, they should be enforced. So in such a situation, such a person cannot get the specific performance of a contract enforced in his favor. Now let's move forward. Or acts in fraud of the contract. So this means this particular clause acts in favor of the contract, that you yourself are committing some fraud, you yourself are at wrong, and now you want still the other person to fulfill the contract. Now say this, in this particular example only, if we assume that B had made up this story about 100 kg of wheat getting destroyed and it was some fraudulent practice on his part because he got a better offer elsewhere and all those kind of things, and he sells this off somewhere else, and this particular entire chain of events is proved in the court of law. Yet still B wants that yes, his obligation against him are fulfilled. So obviously it won't be. This is not equitable. So this is what it is saying. This section is extremely simple. The entire genesis of it is that if I am at wrong, I won't be deriving any benefit out of it. Willfully acts as variance it. So willfully acts as variance with or in subversion of the relation intended to be established. So it means it is almost same with the part which we have discussed earlier. Acts in variance with, acts in variation to what was discussed in the contract. Let's see, if I am not only following the contract, I am performing the contract not as per the terms or conditions discussed in it, but more in the nature of what I am comfortable with, what I feel like doing at that point of time. So that's now how it works. For example, there are two friends, X and Y. This particular person Y has to return money to X, and X has jewelry. It's a pledge kind of a situation. So this particular person Y has to give to X, say rupees 1 lakh. Now how is this person Y returning this sum to X? Some days Y gives him 10 rupees, some days he gives 20 rupees, then he gives 5 rupees, then he gives again 10 rupees, then he again gives 100 rupees. Now just think 1000 rupees. Now just think practically, for a person who has given 1 lakh rupees as a loan to his friend in exchange for a jewelry as security, is this method of payment really reasonable? It is neither equitable, moreover it's torturous, impractical on all grounds. X won't be able to keep a record of how much money has been returned to him. So such situations are what you are acting in variance with the contract. Also you are not honoring or acting with respect to the relationship which exists between you two, which in this case is that of a creditor and debtor. So all such kind of instances, all such kind of situations are covered under clause B. Now let's move on to clause C, and this is the most important clause, and it is where the aspect of cause of action will be related to. Cannot be enforced in favor of a person who fails to prove that he has performed or has always been ready and willing to perform the essential terms of the contract which are to be performed by him, other than the terms of the performance of which have been prevented or waived by the defendant. So section 16C establishes two very important elements, which are readiness and willingness. In short, this clause means if a person who is seeking the specific performance of a contract is ready and willing to perform his side of the obligations of a contract, only then such a person can get the contract enforced in his favor. Now readiness is your financial readiness, your financial capability, your financial ability to fulfill your side of the obligation if finances are involved in a contract, and whether your conduct is such that from it can be manifested that you will be able to perform a contract. So this is nothing complicated, but just try to think of situations where you are acting wrongly but still you want others to support you. Say in a situation of specific performance of contract of selling of immovable property, there is this particular house and there are two parties, A and B. Now A has filed a suit for specific performance in a court of law, wanting that B sells his property to A because there was an ATS in his favor. ATS is your agreement to sell. Now B says that okay, I will sell. In this court there are the proceedings going on, trial has begun or not, doesn't matter. In his WS he says okay, I will sell, but I doubt that A would be able to fulfill his contract, that is A would be able to pay him, because I know that A is under heavy debts, A is under debts, A has a track record of being a financial frauder, A has a track of committing frauds, A has a track of committing frauds, and he also says that his bank account, he has no financial backing to pay him, he has no asset which he could sell, he is not otherwise financially stable a person, he is unemployed and all those kind of things. So what is done by B brings up such contention, such arguments which show that though A wants the specific performance of a contract, but he is not financially ready, he is not financially capable to fulfill the same. Also he might bring up contentions like, I always wanted to fulfill the contract, but it was B who was dodging the fulfillment of the contract, and now he has come up with this entire story and filed a suit against me. I wanted him to come to my house, look at the property at once, but he didn't come. I called him up for signing, I called him signing of the documents, I called him for registry, he didn't arrive and all those things. So those will be a part of the willingness, your conduct which shows that whether you are actually willing to perform the contract. So this is an example of the same. Okay, now talking in context of the 2018 Amendment Act, earlier this particular part in braces mentioned who fails to aver and prove. Aver and prove means that in the plaint it was earlier mandatory to mention the readiness and willingness of a person to perform his part of the contract, because this is an element of cause of action when it comes to suits for specific performance of a contract. In any other case, in a case of specific performance of a contract, instead of the COA having the two elements, that is legal right plus existing of legal right, there is also a third element of readiness and willingness. This is the third element in cause of action of such suits. In no other suit is this third element present. So that is the reason why I was discussing cause of action earlier, that readiness and willingness as mentioned under 16C of SRA is a very important element of the cause of action in such suits. However, after the 2018 amendment, the term aver has been removed. But I want to reiterate that this amendment is of little significance and almost no practical importance, because if we do not prove, if we do not mention the cause of action in its entirety in a plaint, then the plaint is ought to be rejected as mentioned under Order 7 Rule 11A of CPC. So practically speaking, they made this change to make it easier for the relief to be implemented, and it was not difficult for the person to prove his readiness and willingness to make it easier. But practically this amendment is of little significance, and its avering or its pleading in a plaint is equally important even now. Now let's move forward to the explanation. Where a contract involves the payment of money, it is not essential for the plaintiff to actually tender to the defendant or to deposit in court any money except when so directed by the court. So this means that when the suit in question involves some payment of money from plaintiff to the defendant or otherwise. So the fact that you cannot pay it right now will not show that you are financially incapable of doing so. See, practically speaking, when somebody is buying a house or some such big asset, so they do not always have cash in hand, or they don't always have money in their bank accounts, but maybe they have planned on selling off their jewelry, or they are selling off some of their other land, or maybe they are waiting for the sanction of loan. So all these practical considerations are always taken into by the court, and it is something which is to be proved by the plaintiff. So, and not the fact that he actually has money to give it to him right now at that very instance in the court, until and unless the court thinks that that is the case and he should do it so right now. Clause 2, the plaintiff must prove performance of or readiness and willingness to perform the contract according to its true construction. This is obviously the genesis of this entire clause, and according to its true construction is what needs my attention here. It means that as what is written in the contract, without any variations, without any changes, if the person is ready and willing to perform the contract, then he is not barred from seeking this particular relief. So this ends my lecture for today, and I hope that you guys are able to grasp what I'm teaching you all. And do like, share and subscribe my video. Do comment, ask your doubts, give me feedback. Do help me out. I would really appreciate, cause it takes me a lot of effort to work on these videos, and that is why I am doing less of them now. Like I'm not doing them daily. So I hope that you will really appreciate my video and it will soon become viral. So thank you so much.